So here we have, these are excerpts from the Family Law Act. So the overview here is that we've got to be careful when we're dealing with married spouses because of certain rights that married spouses have on the death of their spouse. These rights arise automatically, and the only thing they're really subject to is a marriage or otherwise a domestic contract or domestic agreement that might change these rights. But these are, unlike a dependent support claim that is really a matter of suing the estate and claiming a discretionary relief, this is an absolute entitlement. So a surviving spouse, leaving aside a marriage agreement or other domestic contract, has this right every time that their spouse dies. They have the right to make an election to equalize their net family property. And again, the key here is that they have to be married spouses. This would not apply to common law spouses. So for family law lawyers, you're very familiar with this, but the concept behind the equalization is that there's going to be an equalization of the value of the increase in value of the spouse's property during the marriage, for the most part. That's the idea. And so the Act, without getting too deep into it, is going to look at what is the value of the deceased's assets at the date of death, or the day before death is the way it's drafted. And what was it when they got married? So it's looking at the increase in value. And similarly, it's going to look at the increase in value of the surviving spouse's assets at the date before death of their spouse and the date of marriage. There are certain exceptions for that, like matrimonial homes. But for the most part, that's the concept there. And then if the deceased spouse's net family property or increase in value, in essence, of their assets during the marriage was greater than the surviving spouse's increase during marriage, we equalize it so that both the deceased spouse's increase during the marriage and the surviving spouse's increase during the marriage are the same. That's the effect of an equalization claim. So a spouse always has that right. The downside is that they're kicked out of the will. So they're deemed to have predeceased for the purposes of the will. So in essence, they're put to this election as to whether they prefer what their entitlement is under the will, or whether they want to take this equalization payment instead, in which case they'll forfeit what they would have got under the will. So that is the equalization scheme in a nutshell, to say the least. So there are a bunch of property when you're deciding how much property has gone up in value during the marriage. There are properties that are excluded from that calculation, and there are properties that are included from that calculation. And I'm not going to get into that in too much depth right now. So the one thing that I want to point out is the effect on the will. So if a spouse elects to take their rights under the Family Law Act, two main things happen. One, they lose their right as an executor, and two, they predecease as a benefit. They're deemed to predecease for the purposes of interpreting the will, and including the gifts that they would receive. So that is the impact of that. I'm going to discuss briefly in a few minutes how you make that determination for a surviving spouse. Should you elect or shouldn't you? And we'll talk a little bit about that. But a couple of things that, first of all, even if you elect, that basically if you take under the will, you get to receive all of the property that you get under the will and any property that you are entitled to by reason of the first spouse's death. So joint ownership and insurance and things like that. There is the ability, if a client says, look, I understand that my surviving spouse has this right, And if they do choose that right, they can do that right and still stay as a beneficiary of the will. And you can do that if that's a highly unusual circumstance, but the act does allow that. So if there is a possibility of an election and you discuss that with the client, then this is a provision that should be raised with them that says, look, if you want to let them get what they are going to get under the will plus their equalization, then we've got to put a statement in the will. And that's sub 5 of section 6. So let's look at the situation where we've got a spousal relationship, and let's take the simple solution. You're acting only for Ben here. And Ben says to you that, yes, well, what do you want to do if Laura is alive? Well, I want to set up a spousal trust for her. Okay. So the fact of a spousal trust, of course, is that Lauren doesn't get all the money at once. She is subject to, she gets maybe the income, but maybe the discretionary payments are purely discretionary. So she's not entitled to anything that the trustee doesn't agree to give her. Or there's some limits on the discretion, like if she remarries, she can't get any capital, something like that. So let's assume that's the situation. Well, there is a possibility that Lauren might choose, rather than taking her entitlement under the spousal trust, to elect and take an equalization payment under the Family Law Act that we just described. Why? Because that payment would be paid in a lump sum. She gets it, she has it, she's no longer tied to the executor or the discretion that they might have to give her more or less. So what estate does in this kind of situation, just so we don't have to worry about, oh, we're forgetting to raise this, is if estate sees that there's a possibility of an election here, then what they're going to do, what estate's going to do is warn you that this is an issue to raise with the client. And so, it realizes, oh, they're not getting the entire estate, absolutely. Consider warning the client about the possibility of the election. So what do you do when you warn the client about the possibility of election? That's really what I want to talk a little bit about. So the first thing is you say, okay, well, this might disrupt your plan, because what would happen is that you've set up this whole idea of the trust and everything, and then when she dies, it's going to your kids. Well, what that's going to do is deem to basically accelerate and send you to the descendants only scenario, because the spouse is deemed to predecease. And so now you'd be in the the descendants only scenario, because the spouse is not alive, and the will would be distributed in that manner. The one thing that has to be figured in, of course, is that there's like an initial gift to the surviving spouse in this scenario, because the surviving spouse, if they elect, presumably they're getting a cash payment that's to equalize those net family properties. And so that's going to come off the top. And so that's going to reduce the amount that the kids are going to get, albeit that the kids will get their money without having to wait for the surviving spouse to die. Okay. So that's the effect from a planning point of view. And then you can explain, and then the client might say to you, well, is there anything to prevent her from doing that? And the answer, unlike a dependent support claim, is yes, there is something. You could get a marriage agreement, which would be binding to, assuming it's valid and everything else, but would be binding to oust the right of the surviving spouse to an election. Right? And under dependent support, an agreement doesn't absolutely bar a dependent, but under the Family Law Act, it would absolutely bar a claim, assuming it's valid, by the surviving spouse. So that is something that the client can do. So that's one warning that you can give them. The other idea is, okay, then you could raise the issue, okay, if they did make an election, would you still want them to get certain gifts under the will or not? It's going to also make the decision about executor relevant, because they're not going to be entitled to be the executor of the estate if they elect. And that's a case that stands for that proposition called Reed and read Martin, and we can follow up with an email with everybody with that information about that case. A very old case, but still a good law. And so that's really what you can explain to the client about the equalization claim, because the surviving spouse, absent a domestic contract, is going to have that right. And you might get into a situation where you try to figure out, the client says, well, I don't want there to be this, I don't want them to elect, I want them to take under the will. And then you get into a situation of trying to figure out, okay, what would their equalization claim be? And can we give them more than they would get under the equalization, which would discourage them from making the equalization? That's a calculation that's fraught with peril, because of course you're using numbers that you're just estimating. You have no idea what the values of certain assets are going to be on the day before death. And so it's difficult. The one thing you can pretty much guarantee is that if you give them 100% of the estate, that they're going to do better than or at least as well as under an election. But otherwise, it's very difficult to determine. So those are those comments on the planning side of things. The fundamental concern I would have when considering the election, and this ties in somewhat into the planning. So when an election is made and there's an equalization payment on death, there's a specific provision here on section 6 sub 6 right here that adjusts the equalization payment. So if the surviving spouse was entitled to $500,000, let's say, if they had separated, which would be the same sort of calculation, there's a difference in if it's an equalization payment on death. And that difference is that spouse has to credit that against that $500,000 equalization payment, the amount of the payment that the spouse receives as a beneficiary of life insurance, for example, a beneficiary of a lump sum payment under a pension or similar plan, or joint property. So if they were entitled to a $500,000 equalization payment, but they were getting $600,000 under a life insurance policy, their equalization payment is worth $0. Okay, so you wouldn't make that equalization payment. But even worse, if that amount that they're crediting against their equalization, that life insurance policy, exceeds the amount that they would receive as an equalization payment, they actually have to repay the estate the difference. So elections have to be very carefully considered by a surviving spouse. It's not something that you take lightly as an advisor, because of this draconian event here, where if you didn't know, for example, you might look at the will and say, oh, you're not getting anything under the will, make an election. So you go out and you make the election. Little do you realize that he or she was a beneficiary of a life insurance policy, or a pension, or jointly held property. And now this election that you were going to get $300,000, you actually have to tell your client, oh, by the way, you got to pay money back to the estate. I mean, that you can see as probably a pretty clear negligence claim or potential negligence claim. So making an election under the Family Law Act, if you're thinking of it from that point of view, is very, very dangerous and should be very, very carefully considered. The other problem with it is you can't really revoke an election once made. So if you rush out and you make that election, then well, don't worry, I'll pull it back if I'm wrong. That doesn't really exist except under very extreme circumstances. So you better be pretty sure before you make that election. The election has to be made 6 months after the date of death, which is a different limitation period from a dependent support claim. This starts running from the date of death. Often, you don't have any idea of the true equalization payment entitlement for more than 6 months, but you have to make that election within 6 months. So what you have to do then is, don't guess, you have to get an extension, which is regularly granted if brought within the 6-month period, to extend it until you have the information that you need to make that determination for the client, or to advise the client properly and let them make the determination, which is more properly the case. So those are some of the issues with elections, and very important on the administration side if you're advising a potential surviving spouse. We talked a little bit about this idea that, oh, well, how do I prevent an election or an equalization claim? Well, one of the ways is to stack it up with insurance, right? So if you give that spouse insurance, well, that's going to get credited against the equalization payment dollar for dollar. So that's one way to discourage an equalization claim. Yes, so that's the, this is just so you know where I've referred to some things. Section sub 8 is where's the deeming provision that says the gifts are revoked and the will is interpreted as if the surviving spouse had died at predeceased. So those are the sorts of things that I wanted to go over. Let me just see if there was anything else that I wanted to talk about here. Just give me 1 second. Yes, okay, we can talk some more about that if there are questions. So that's really, that's what I wanted to talk about. Anybody have questions about, from a planning point of view, how the Family Law Act applies in respect of this issue specifically?
Yeah, Jordy, it's Fred. Just an interesting situation where I've got very well-to-do clients, both individually well-to-do and also have assets in common, and they are both agreeable to, and I haven't done the full, consideration of what equalization might look like. It's kind of complicated, but they're both agreeable that they, want really the bulk of the estate to go to, kids or stepkids or whatnot. And so at this point, they're agreeable. And, I've provided my caution, and there's more work to be done, of course, before giving them final guidance on it. But, what kinds of things can you do to document that, or where people are in agreement at the planning stage, but maybe, after the death of one of them, that's where disagreement arises.
Right. So that's a domestic contract. That's, I think what I would recommend is say, it sounds to me that what you want to do can be accomplished by a domestic contract, and that's really how you would document their intention. They would waive their right to an equalization payment. They would probably waive rights to dependent support claims, but that's not as binding. But that's likely how you would have to deal with it if, because especially if that's what they want to do. See, this is where we get, lawyers can't win, right? So let's say you don't say anything. You say, okay, well, these are the intentions, and you don't recommend a separation agreement. Well, then if it turns out that they do make an equalization claim, and the kids say, well, dad and mom and stepmom had agreed, and you didn't, document it or whatever, I mean, then you can get in trouble that way. So, there's lots of ways we can, step into a minefield here. But that's what I would recommend in that situation. Does that, Fred, answer the question?
Yeah, that's helpful. Thanks, Jordy. Thank you.
Yeah, it sounds like what exactly you're trying to do there. There was a question from Camilla. Anything we need to be aware of when drafting separation agreements for clients, for example, want to say that the only beneficiaries will be the children. So we're going to talk about next week this concept of mutual wills, which ties in to the whole issue of agreements and marriage agreements and cohabitation agreements. So we'll talk about that. This is in drafting a separation agreement, though. So Yeah, I mean, you can contract with your client, with your spouse and your ex-spouse, that you're going to do certain things for the kids, and that is typically enforceable. I'm not a family law lawyer, so I don't know for sure, but I would say that that is not uncommon to see where the parties have agreed to designate the children as beneficiaries of certain assets. I mean, maybe you get into privity of contract issues there, and I actually haven't dealt with that recently, and I have dealt with it before because we used to do a fair bit on separation agreements, but typically the court would enforce that in my experience, but that's not uncommon in separation agreements. So question for Bill, from Bill: what other assets other than insurance for stacking? So maybe I'll just show you what I mean. I think when you say stacking, like counting against the share credited, that's in section 6. So it's policy of life insurance. It's a beneficiary of a lump sum payment provided under a pension or similar plan. I typically interpret that to include an RSP, a registered plan. I realize now I'm not sharing, so hang on a second. Let me just do that. So it's 6. So it's life insurance, beneficiary of a lump sum payment under a pension or similar plan. It seems to track the wording of the Succession Law Reform Act, and that's why it's generally accepted that that would include an RSP. And then also joint property. So those are the 3 categories.
Jordy, can you hear me?
Yes.
It's Bill. Yeah.
Okay.
What if it is an RRSP or a TFSA or whatever? How is the tax treated?
So subsection 7 is deals with contingent tax liability, et cetera. So there is some provision for that. I haven't looked at the issues recently, if there's case law exactly on that, but maybe we can look that up and see just how courts have dealt with that. Because you're right, it's not worth after-tax dollars, the same as after-tax dollars. So, but there is a provision in there that deals with that.
Okay. Thank you.
Jordy, it's
Yes.
Teresa. I have a question. I know that you're very clear about only representing one of the spouses, but obviously we can't always just.
Yeah, I'm the only. That's only in a blended family, by the way.
Okay, so I have a situation where I have, met with the couple, and of course talk about the joint retainer and all of that. And then in our meeting, I discovered that they do have a marriage contract where the spouse does waive because he is a very wealthy individual, and basically she entered into the prenup. And so I have another meeting with them coming up, and I'm just concerned about, professional responsibility, because he's now saying, hey, I've got this, the prenup, I want to do the spousal trust, but she's on the call and she's crying. And then so that's why we end up not finishing the meeting. It's been postponed for about 3 months, and now we're having another meeting. I'm just wondering, other than talking about the fact that it's a joint retainer,
this is not going to end well.
Yeah. So do you recommend saying that, I'm going to step out, or?
Yeah, I would not. If I've got one client in a joint retainer crying about what the other client is telling me, that's a pretty good indication you can't act for both of them. And nor does it make any sense to act for both of them, in my view. I mean, this is, again, just purely my view, but like, how can you give her proper advice, and how can she feel you're on her side and all of that? Like, that is one, yeah. And that's the reason, I have this hard and fast rule. Many of the cases would be fine, but I just find that by the time I get down the road, that's why I don't, and maybe that's another topic is joint retainers, but yeah, that would scare me for sure.
So if we've already taken on the engagement, like, we can at any time just say, you know what, I don't feel comfortable continuing. And can I still retain one of the spouses though? Even though I've met with both?
If they'll agree.
Okay.
Yeah, I think if it was a joint retainer already and you yeah, I think generally the rule is you have to resign from both if you can't act for both. But yeah, it's a very, and you know what, that's going to be our topic in 2 weeks is how to manage joint retainers with spouses. So, but yeah, that one would be concerning. And Teresa, I'm happy to talk offline just because this is
Okay,
a bit of
sure.
probably a private thing. So
Okay,
yeah,
thank you.
it's a common problem and one that we'll definitely discuss in 2 weeks.
Okay, thanks.
Sure. Any other questions about FLA elections and planning for them? No. Okay. Well, that's good. Any other questions about that people have? I just wanted to mention a couple of things while you guys are on the line. We've added a whole bunch of new advisor insights that are going to warn you about, either you've, missed, not missed, but you have forgotten about putting, or the client has forgotten about naming a guardian for minor kids, or we got Family Law Act elections, or we have LTQ property that might qualify, Henson trusts if it spots that you haven't created a Henson trust for a disabled person, it'll just give you a warning about that. Just make sure you're okay. So we've added about 20 new ones to, again, the concept here is to help us not have to worry about remembering everything. And so that's what we continue to build out. And we'll have some additional news about other new features in the next couple of weeks, which are going to be relatively dramatic. So and good news for a lot of us. So